everybody, and welcome to our weekly Facebook Live webinar. So, for those who don't know me or who haven't joined us before, and this is your first time checking in with us on our weekly HR webinars on Facebook, my name is Pearson, and I'm from Pinnacle People Solutions. And as I said, welcome to our weekly webinar about all things HR. So our company, Pinnacle People Solutions, provides human resource services advice, solutions, support, strategies, you name it, to regionally based small to medium-sized businesses and not-for-profit organisations. We are here to help you and your business adapt and thrive. You can contact us, either myself or my phenomenal team, anytime via Facebook, email, or telephone. And good evening to those who are joining us and cheering us on in the chat screen this evening. Delightful to have you with us. So you can contact myself or my fantastic team anytime via Facebook, email, or phone, and or you can visit our website at pinnaclepeoplesolutions.com.au. So as a continuation of our COVID-19 employer advisories, every Wednesday evening at 5:30, we'll be doing a deep dive into a particular HR topic to provide information and insights on topics of interest to regional business. And we are largely guided by what our clients and our supporters and those who are listening into us each week would like to know more about. So if there is anything that you'd particularly like to hear about, don't hesitate to get in touch. If you're watching this on Facebook, you can subscribe to receive notifications of when we're going live on Facebook by clicking the bell icon in the top right corner of your screen. That way you'll never miss a HR update or webinar from us ever again. So if that appeals to you, go ahead and click that bell icon in the top right-hand corner of your screen. So today's webinar is all about the what I've called the employment nasties. How to handle them and how to avoid them. And these are the things today that we're particularly going to focus on: unfair dismissal, general protections disputes, and workers' compensation claims. And invariably, from my experience, these are the aspects of being an employer that most business owners and managers hate and generally end up making them very unhappy, and occasionally businesses insolvent. So really important topics for us to be talking about. So let's get straight into it, because your time is valuable and we want to make sure that you make the absolute most of it whenever you're tuned in with us here on Facebook. So there are 4 ways in which a dismissed staff member can take action against you as a business owner. Unfair dismissal is the most common remedy that a dismissed employee would seek, but there are other types of claims available. And so tonight I thought would be an appropriate time to go through each of the 3 main areas that cause grief for employers and what you can do about it. So what are the factors that an employee might consider when deciding to take action against their employer or their previous employer? If somebody is dismissed, if you dismiss a staff member, they can pursue you through 4 possible avenues depending on their particular circumstances. The first is unfair dismissal, and that's subject to certain eligibility rules, which we will talk about in just a moment. So that's unfair dismissal under the Fair Work Act. There are also general protections under the Fair Work Act, which we're going to cover also today. There's discrimination under federal, state or territory equal opportunity legislation. We're not going there today, but that's a separate topic for us to cover at another time, as is common law actions for breach of contract. So both of those we're going to leave for the moment, but we're particularly interested in unfair dismissal and general protections disputes this evening, as well as workers' compensation claims. The 2 areas most commonly accessed by employees are unfair dismissal and adverse action applications, which is under the general protections provisions of the Fair Work Act. To be really clear, your employee needs to decide which remedy to pursue, because multiple actions for the same conduct are not allowed. Just to be really clear, that's to prevent somebody from double dipping when they have multiple potential remedies available to them. In all cases, the anti-double dipping provisions I've just mentioned don't apply where somebody makes an initial application that they then withdraw or that fails because it was made in the wrong jurisdiction, for example. Any application must be made within 21 days after the dismissal took effect. Obviously, any staff are going to take into account the potential remedies that are available if they were to be successful when they're working out which avenue that they might want to take. And let me tell you, the numbers and volume of complaints and cases are absolutely exponentially on the rise. It is an absolute area of risk management for small to medium-sized businesses and not-for-profit organisations. Too many times we've seen one of these claims really cripple a business, and in a couple of cases actually mean that they weren't able to continue to operate. So they can be pretty serious, and the fact of the matter is we are living in days and times when employees, and I think this is a good thing, are very much more informed than they ever have been before about their rights and entitlements, and increasingly prepared to access them. And to defend and to take action against employers that they think have not given them appropriate entitlements or taken inappropriate action against them. So this is timely for us to be talking about this, in particular because, and the first area we're going to talk about is unfair dismissal, in particular because unfair dismissal claims have increased by 70% during the coronavirus crisis. The Fair Work Commission have talked a number of times in the media about dealing with an unprecedented caseload. So it's kind of not surprising with JobKeeper and all of the elements around that. There's a lot of complaints coming forward, a 70% increase just during coronavirus. So you don't want to be one of the employers that's found to be on the back end of that. So let's talk then about unfair dismissal. While it is the most common claim that's made to the Fair Work Commission, the access to it is restricted to certain employees. So the following are categories of employees who can't claim unfair dismissal. The first is someone who's served less than the relevant minimum period of employment with you as the employer, and that is generally 6 months, although businesses that have fewer than 15 employees, and by that I mean headcount, not full-time equivalent staff, have 12 months. So if your staff member has served less than 6 months if you've got over 15 staff, and less than 12 months if you've got under 15 staff, then they're not eligible to lodge a claim for unfair dismissal. If they are award or agreement free, so if they're not covered by a modern award and their annual rate of earnings exceeds the high income threshold, which is currently $153,600, that goes up on the 1st of July each year. It's generally indexed. And so that is the current high income threshold. If they are award or agreement covered and their wage is above that, they are still covered by unfair dismissal. So they have to be not covered by an enterprise agreement or a modern award, and their rate of earnings needs to be higher than $153,600. Where the reason for the dismissal was a case of genuine redundancy, that's also not an area of eligibility that somebody can put in a claim, or where somebody is pursuing other termination of employment proceedings. Like I mentioned earlier, they can't do the double dipping part. If somebody is eligible to claim unfair dismissal against you as an employer, there are a number of considerations which need to be taken into account to determine which course of action they might take. So that will include the maximum amount of compensation which might be awarded in an unfair dismissal claim, and that is based on the equivalent of 6 months ordinary earnings, up to a maximum of $76,800 from the 1st of July and indexed each year. The Fair Work Commission also, it's not a court. Consequently, legal costs may be less for an adverse action claim than for an adverse action claim. Also, many applicants in unfair dismissal matters represent themselves, and the vast majority, over 95% of cases, actually settle at conciliation, which is the first step following the submission of an unfair dismissal claim. For unfair dismissal claims, the onus is on the applicant, so the person making the claim, to prove that their dismissal was harsh, unjust, or unreasonable, and that the reason for the dismissal was invalid. So the onus is on the applicant to prove that. And as I mentioned, most of the unfair dismissal applications that are heard by the Fair Work Commission are mediated and settled prior to arbitration. So one of the things that we've experienced in terms of claims that get lodged with the Fair Work Commission is that often the claimant application is actually ineligible, and even when the respondent, which is the employer, comes back to the Commission and says, the Fair Work Ombudsman, and says, look, we don't believe this applicant, that application is actually eligible, they won't dismiss it necessarily at that point. They will still generally go to a conciliation to prove that the applicant's application for unfair dismissal is ineligible. So just bear that in mind. You've often still got to go to a conciliation in order to establish that. Essentially, in order to establish that somebody has been unfairly dismissed, the Fair Work Commission needs to be satisfied that, first of all, the person has actually been dismissed. Second of all, that the dismissal was harsh, unjust, or unreasonable. Thirdly, that the dismissal was not consistent with the Small Business Fair Dismissal Code, and I'm going to talk a bit more about that. And that the dismissal was not a case of genuine redundancy. So who can bring a claim then of unfair dismissal against you as an employer? So the Fair Work Commission must determine the following matters before the merits of the application can be heard. So whether the application was made within 21 days after the dismissal took effect, bearing in mind that the Commission can be very generous, and if somebody argues that they haven't been able to submit within the 21 days because of illness or some other kind of unavoidable circumstance, the Commission's often quite flexible about them being a bit late with submission. So that's something just to bear in mind. Whether the person had completed the relevant minimum period of employment. So as I said, 6 months if you're under 15 headcount and 12 months, if you're over 15 headcount and 12 months if you're under. Whether somebody was covered by a modern award or an enterprise agreement, and whether they had earnings less than the high income threshold if they're award free. There are certain types of categories of applicants who fall outside the ability to make a claim. If somebody was on a fixed term contract and that contract was valid and that has terminated as a matter of course, if somebody was subject to a training arrangement and their employment was terminated at the end of that arrangement, so say an apprentice or a trainee, if somebody was demoted in employment but the demotion did not involve a significant reduction in their remuneration or duties and they remained employed by the same employer that brought about the demotion, the person could have been dismissed for serious misconduct. The person's dismissal was a case of genuine redundancy. Someone's yet not completed the relevant minimum period of employment, and contractors. Now, casual staff are generally excluded from bringing an unfair dismissal claim unless, and this is the kicker, they've been employed on a regular and systematic basis for at least 6 months and they have a reasonable expectation of continued employment. Now, a lot of employers are employing casuals for which that would apply, and therefore they may have remedy in unfair dismissal. So that is really important to bear in mind as an employer. Serious misconduct, so I mentioned before, that doesn't relate in terms of unfair dismissal, and that's willful or deliberate behaviour by a staff member that's inconsistent with the continuation of their contract of employment. Genuine redundancy is change of operational requirements where a machine is now available, for example, to do the job of somebody who was previously an employee. The employer's business is experiencing a downturn and therefore the employer only needs 3 people to do a task instead of, for example, 5. And an employer is restructuring their business to improve efficiency and the tasks done by a particular employee are distributed between several other staff and therefore the person's job no longer exists. So redundancy is a whole other area of that you need to get specific advice and assistance with. There's been a number of cases of that I've come across during COVID where employers have decided to go down the redundancy path to otherwise deal with conduct or performance issues, and it hasn't been an appropriate process or a genuine redundancy, and they've found themselves on the end of an unfair dismissal claim. So just be really careful with any workplace structural change. Not that you can't do it, not that you don't have a lot more flexibility during COVID if you're a JobKeeper eligible business and it's a staff member who's receiving JobKeeper. But you do have to be really careful to get the process right and to make sure you don't leave yourself open to vulnerabilities in respect of that. So there are different rules. One of the questions we often get is, are there different rules for a small business employer? The answer is kind of yes. There is such a document as called the Small Business Fair Dismissal Code, and we will give you some further information about that. And the code is a less stringent requirement on the employer than the rules that would be expected from somebody who has more than 15 staff. It provides essentially a checklist for small business employers, which serves as a tool which may be used in the event of a future unfair dismissal claim in which an employer relies on compliance with the code to oppose the claim. My experience is that's not always successful as a defence, particularly if it hasn't been, if due process hasn't been followed appropriately. So please get advice before you go about this any process of terminating that might lead to terminating a staff member's employment, because you just want to make sure that you have your ducks lined up appropriately. So what factors are considered in determining if a dismissal is unfair? As I said, there are a number of factors that the Commission will consider. One, is there a valid reason, or was there a valid reason for the dismissal? Whether the employee was notified of that reason, whether the employee was given an opportunity to respond to the reason given, was a support person present if requested by the employee, whether the employee had been warned of unsatisfactory performance, the likely impact the size of the employer's business has on procedures followed in effecting the dismissal, the likely impact and absence of a dedicated HR personnel may have on procedures followed affecting the dismissal, and any other matters that the Commission considers relevant. Now, here's the interesting thing, because we often have employers ask us this: is a valid reason sufficient to defend an unfair dismissal application? And the unfortunate answer to that question is no, not always. While you might have a valid reason to dismiss someone, and dismissal can still be deemed by the Fair Work Commission to be harsh, unjust or unreasonable. For example, poor leadership skills may be a valid reason to dismiss a manager. However, if that manager was not warned of their poor performance and that their employment may be at risk, the dismissal could be viewed as harsh and unfair. So let's unpack that a little bit more. So in terms of what is meant by harsh, unjust or unreasonable, harsh is determined based on its consequences for the personal and economic situation of the employee, or because it was disproportionate, for example, to how serious the alleged offence was that they committed, or poor performance or whatever it was. Unjust because the employee was not guilty of the alleged offence on which the employer actually took action. And unreasonable because it was decided on inferences which would not reasonably have been drawn from the material before the employer. So that's the definition of each of those things. It may be, for example, that the termination is harsh, but it's not unjust or unreasonable. Unjust but not harsh, or unreasonable but or unreasonable, or unreasonable but not harsh or unjust. So in many cases, the concepts are going to overlap. Thus, the one termination of employment may be unjust because the employee was not guilty of the alleged misconduct. It may be unreasonable because it was decided on inferences which couldn't have been reasonably drawn from the material that the employer was working from. And it may be harsh because the consequences for the staff member are significant or disproportionate. So the other thing I want to say to you about dismissal, which usually precedes an unfair dismissal claim, not always a general protections claim, and we're going to get into that, one of the questions we often get asked is, how many warnings must an employee receive before dismissal? There is no specific number of warnings that need to be issued by an employer to an employee before dismissal can occur. So when a written warning is issued to an employee, it should contain the following details. It should contain the details of the performance or the conduct deficiency, stating in specific terms, for example, details of the staff member's absenteeism record, if that's the issue. It should reference your company policy and procedures, where the performance or conduct involves a breach of them and specific description of what the breaches are. It needs to include the details of the corrective action that you require from the staff member, and a time frame, either a deadline for improvement or a date on which performance will be reviewed again. And it needs to state the intended action if performance or conduct does not improve to a satisfactory level. For example, employment might be terminated. The maximum amount of compensation that somebody can get from the Fair Work Commission is 6 months' pay, up to a maximum of $76,800. Now, the fact of the matter is that our experience of Fair Work Commission payments for those that are found to be justified, the application is found to have merit, is that kind of maximum payment is generally only reserved for long-standing staff and a particularly serious breach by the employer. It's generally, you generally get, significantly less than that. And often more than 95% of cases of unfair dismissal are actually resolved at conciliation, which is the first stage. While we're on the topic of unfair dismissal, and before we go on to general protections disputes and to workers' compensation claims, I want to talk just briefly about constructive dismissal. So what is that, is often what I get asked. This refers to a situation where there's the termination of an employee of his or her contract of employment in circumstances where their conduct has been such as to make the employee feel obliged to resign. So that is, had the employer not taken the action it did, the employee would have remained in the employment relationship. So it can also be referred to as a forced resignation. Now, why is that distinction important? An employee can successfully claim before the Fair Work Commission that their resignation was in fact a termination constructed by the employer and consequently was a dismissal initiated by the employer. That means that the dismissal could be determined by the Fair Work Commission as unfair, with reinstatement or compensation as possible remedies. So what are some of the examples, let's say, of constructive dismissal? Where the employee is effectively instructed to resign by the employer in the face of a threatened or impending dismissal, resign or I'll sack you. Or where the employee quits their job in response to conduct by the employer which gives them no reasonable choice but to resign. So they could no longer remain employed in that situation. For example, a staff member who resigns after getting paid half wages could be regarded as a forced resignation due to the conduct of the employer and would constitute a dismissal by the employer. For example, an employee who resigns after falsely being accused of theft could be found to have been constructively dismissed if they said, I can't work there anymore. Important to know about constructive dismissal as well. So all of this points to the fact that employers need to be so careful about any action that they take in respect of their staff, including terminating employment. So let's have a quick look then at adverse action, which is the general protection provision. So general protection applications relate to adverse action taken by one person against another in relation to the workplace. So essentially what general protections deal with is the protection of workplace rights and the exercise of those rights by staff members, the protection of freedom of association and involvement in lawful industrial activities, providing protection from discrimination, that's an overlap with discrimination laws, and sham arrangements. The most common adverse action by an employer is dismissal, although adverse action can also include injuring an employee in his or her employment or altering the position of an employee in a way that prejudices them, discriminating between the employee and another employee, refusing to employ a prospective employee, or discriminating against a prospective employee in the terms or conditions in which the employer offers to employ them. So examples can include things like demotion or being overlooked for promotion because of the employee's legitimate activities at work. The most common allegations regarding adverse action are that the dismissal was based on discriminatory grounds, or because the employee was a union delegate, or the dismissal was due to somebody's temporary absence due to illness or injury, or the employee was dismissed or victimised for exercising a workplace right. So the Fair Work Ombudsman has successfully prosecuted a number of employers over time in relation to things like discriminating against staff coming back from parental leave. As an example, we've had significant numbers of employers fined significant amounts, paying compensation, and employers being made to have to undertake enforceable undertakings. So why should you then, as employers, be particularly concerned about adverse action claims? Let me be really clear about why you should. There are a number of reasons that I actually think that adverse action claims under the general protections provisions potentially present a greater problem for you than unfair dismissal claims. The main reasons why a dismissed employee may pursue an adverse action claim rather than an unfair dismissal claim includes it's a wider jurisdiction. So adverse action applications are open to prospective as well as current employees, as well as contractors and other workers. So it has a wider landscape. There is no minimum period of employment that must be served in order to qualify. So unlike unfair dismissal, where it's 6 or 12 months, depending on how many staff you have, over or under 15, there is no minimum period of employment. So general protections provisions kick in from the first day, or even the recruitment before the first day has even started. General protections provide broader remedies, including injunctions that can be made against the employer. And while there are time limits for lodging claims, while the time limits for lodging claims are the same as for unfair dismissal, damages are not capped at that 6 months pay maximum. Also, and perhaps most significantly, there is a reverse onus of proof under general protections applications, which means that employers are effectively guilty until proven otherwise. And as adverse action applications are eventually heard before a court, legal costs for proceedings may be a consideration for an applicant, although not if they happen to get pro bono legal assistance, although there have been instances also of self-representation before the Federal Circuit Court. So from the employer's perspective, the cost and difficulty of defending general protections claims is largely caused by that reverse onus of proof provision, which means that you're guilty until you can prove that there wasn't actually a connection, that you didn't take adverse action against somebody for the reasons that they're saying, that you terminated them or you demoted them or you took some other kind of claimed adverse action against them. Let me give you an example of a case of adverse action. So while it obviously could be uncomfortable for both you and the employee if somebody approaches you and questions whether you've been paying them correctly, for example, there is no doubt that the staff member is entitled to do that, and you certainly shouldn't terminate their employment. One employer unfortunately found this out the hard way after they terminated a staff member who queried his pay and entitlements, and the employee won a claim for adverse action as a consequence. Now, what actually happened is a driver engaged by a waste recycling business had been dismissed when he made inquiries about his wages, and he suggested that to the company that he'd been underpaid. The employer, the waste recycling business, denied having any knowledge of his complaints and inquiries regarding his pay rates and employment status. The business also denied the decision to terminate his employment was because he exercised his workplace rights to ask about his pay. On balance, the court found the evidence clearly favoured the employee. Although the applicant conceded he occasionally may have failed to secure the tarpaulins on his truck, he attributed this to difficulty in reaching the tarpaulin knots. He also conceded that had he been asked at least once to put on, he also conceded he had been asked at least once to put on a fluorescent vest, which he should have, but was not wearing in the yard at the time he was terminated. He was not, however, at any time reprimanded or given a formal warning in respect of any of these matters. So this is what becomes so important, to document the conversations that you have with staff if you've got performance or conduct issues. Because in this instance, they clearly did have issues, but they hadn't documented them, and he acknowledged that they were issues, but the Commission still found that there was a connection between his pay queries and the company terminating him. The court concluded that his complaints about his employer's failure to pay his full entitlements under the award was a substantial and operative reason for the decision to terminate his employment. Now, that's the reverse onus of proof, don't forget. So the employer had to prove, was guilty until they could prove that they weren't. And unfortunately, on this occasion, they weren't able to prove that that was the case. What do these things mean for your business? First and foremost, in terms of either unfair dismissal or general protections, you need to be absolutely scrupulous in following your HR policies. If you don't have those policies, if you don't have employment contracts or position descriptions in place for your staff, you need to get that sorted as a matter of urgency. The aim is to avoid an an adverse action or an unfair dismissal application. Note that the standard of proof used by courts and tribunals in dismissal cases is the balance of probabilities, except in the case of adverse action claims when the reverse onus of proof is at play, which means the employer is guilty until they can prove that they're not. The more serious the allegations are that might be made against you in any claim like this, the more certain you need to be that the conduct occurred. This is particularly the case of claimed adverse action claims where there's the reverse onus of proof. So that is the overview of unfair dismissal and general protections claims. The third that I was going to discuss this evening are workers' compensation claims. Now, workers' compensation claims, everybody who's employed by an organisation has an option to submit a workers' compensation claim if they are rendered ill or injured as a consequence of their work. My advice on workers' compensation claims, in terms of if you ever get one or when you get one, is get advice immediately. It's incredibly important with such claims to know the process or to get expert advice immediately from people who do know the process. Understand what you have to do and to whom you need to report. Know your risks and manage them. You can be fined or jailed for work health and safety breaches, and workers' compensation claims I have seen bankrupt small business. If your workers' compensation premium is above $30,000 a year, any lost time injury will be impacting on your premium, and in quite a significant way. I want to give you an example of a workers' compensation claim that was successful, because some of the ones that we see often relate to performance conversations or processes. So in general terms, employees are actually excluded from claiming workers' compensation for mental injuries resulting from their employer's reasonable management action. For example, a performance review. However, a recent case of an overly aggressive approach to performance management by a HR manager saw an employee entitled to workers' compensation for the resultant mental injury. The employee began to suffer generalised anxiety disorder and associated panic attacks with agoraphobia and major depressive disorder as a result of a performance review. She testified that the HR manager had come to her office in March 2012 and asked, "Can you come with me? I'd like to have a chat." She also gave evidence that she asked the HR manager whether she would need to take a pen and paper, to which the reply was, no, it's just a chat. Then she said the HR manager advised her that employees had made allegations or complaints about her. No one else was present during the meeting, which went for 2 hours with a number of allegations and complaints canvassed. The employee already knew certain complaints had been made about her, but at the start of the meeting she was not advised it was an investigation. The employer argued in this case that the HR manager had engaged in reasonable management action. However, the employee said she felt degraded, intimidated, harassed, hurt and disbelieved. She hadn't been warned about the content of the meeting. The employee said she told the HR manager she felt shocked and believed staff were victimising her, but she was ignored. So this was a matter held in the ACT Magistrates Court, and the presiding magistrate said that the employee was entitled to workers' compensation for her mental injury, noting it had left her totally incapacitated for work. He said that the employee's reaction should have alerted the HR manager to inquire about her welfare and whether she wished to continue with the meeting. The employer appealed the magistrate's decision to the Supreme Court. The Supreme Court decision was that the HR manager's failure to give the employee advance warning of the issues to be raised, complaints that were highly critical of her work performance, was calculated to cause shock, and that this was compounded by the length of the meeting and the number of allegations presented without notice. In rejecting the employer's appeal, the Justice said, "I find that the lack of warning, the continuous allegation of wrongdoing for an excessive period of time and without paying heed to the applicant's expressions of denial, upset and discontent was an unreasonable means of conducting the meeting, and that the unreasonable conduct was the cause of the applicant's injury." So here's the bottom line. Whether management action was reasonable management action is often the subject of litigation. So the concept of acting in a reasonable manner underpins this concept, and consequently all of us as employers should be careful to act in a fair and even-handed way to avoid adverse findings. So what are the practical realities for you as employers around this space in terms of minimising your risk of unfair dismissal, adverse action under general protections provisions and workers' compensation claims? There are 6 things that you need to know about termination in particular. Now, it doesn't mean that you couldn't be found to or have a claim made against you for adverse action against an existing employee. Termination, somebody might not have left your employment for these things to come up, but let's kind of concentrate on that because it's often the most frequent situation. You need to note the following issues when a termination of employment occurs. The termination, first of all, must be lawful. The date and the reasons for the termination must be clear to all the parties. Whoever initiates the termination, whether it's you or the staff member, should do so in writing. You and your employee must comply with notice periods required by legislation, awards, or the contract, whichever is the most generous. Employees must receive payment of their accrued entitlements. You must, as the employer, meet documentation requirements such as keeping payroll records, providing statement of termination entitlements and calculations, and a certificate of service. You should collect any employer property issued to the employee before they leave. And get sound advice is my advice. Establish your expectations up front when you first employ somebody. Get that in writing in an employment contract and a position description, and communicate to your staff regularly. Follow your policy. If you don't have health and safety and work and HR policy in place, get it in place and follow it, and be clear on your expectations and your obligations. Make sure your position descriptions are up to date. Be consistent and be fair. Document processes that you go through with your staff. Give notice of meetings and make sure that they've got the opportunity for support if they need it. Maintain strict confidentiality, and remember that due process is your friend. The way that you handle issues is just as important as the issues that you're handling. Thank you so much for joining us this evening. I hope I haven't scared people too witless, but these are really important areas, the nasties, for employers to be cognizant of. Thank you so much for joining us this evening. This video, as all of our videos, will remain online on Facebook. It'll also be available on LinkedIn, YouTube, and our website if you'd like to catch up or you'd like to watch it again later. We'll also be providing a fact sheet based on the information provided that you'll be able to download from our website shortly. You can also sign up for a weekly digest of our Wednesday webinar, the associated fact sheet, and our Monday news update to be delivered to your inbox every Tuesday on our website. So you just have to go up to our website and register, and you can get that information. Please join us next Monday for our next Monday news update at 9:15 on Facebook to catch up on all the important news from the last week and COVID related as well as general HR. Our webinar next Wednesday will feature JobKeeper 2.0. Are you ready? So tell all your colleagues, friends, and family who want to know how to know if they're ready for JobKeeper 2.0, and tune in to us next Wednesday at 5:30. In the meantime, please hug the people that you can. Please wave cheerily at those that you yet can't. Stay safe. Stay socially distant. Keep up that fantastic hygiene. Wear a mask, and we'll really look forward to seeing you on Monday. Thank you so much for your time.